Welcome to this new episode of the Privacy Rules Privacy Espresso. Today I'm joined by our expert from Portugal, Tiago Félix da Costa from the firm Morais Leitão. Tiago is partner and head of their compliance and data protection team, and we are going to discuss direct marketing and the EPrivacy Regulation. And I would like to immediately start on this topic asking how was the direct marketing law in Portugal so far, and which changes will the EPrivacy regulation entail?
Thank you, Alessandro. Hi, everyone. It's a pleasure to be here. Well, although there is not an official statistics, I can tell you that we believe that 80% of the investigations and the regulatory proceedings since May 2018 within our data protection agency are related with direct marketing complaints. And so our regulation, our law is from 2004. It's already very old, like the EPrivacy directive, and it was subject to some controversy in Portugal. And so we believe that's a hot topic for us, and we believe for everyone, at least in Europe, or everyone sending direct marketing to people, citizens in the European space.
Okay, perfect, Tiago. Thank you very much. And do you also think that the EPrivacy regulation may bring some opportunity to businesses?
Yes, I believe that we will see that with our brief presentation. This is an espresso, so we have to move quickly. First, what's new? And when we are saying new, it's not new to the latest draft of the regulation, the previous draft of the regulation, but new regarding the EPrivacy directive, considering the draft of January 5th. Already presented under the Portuguese presidency of the EU. So, e-privacy provisions on direct marketing appear to be applicable to a broader reality than e-privacy directive, including now all electronic communications. And it's interesting because if you go deep on Article 13 and Article 4 with the definitions, you will see that although Article 13.1 establishes prior consent for direct marketing to all electronic communications, you won't find the definition of electronic communications. But one can say that, of course, we are discussing the differences between directive and the regulation, but we can say now that all electronic communications are under the same general rule, which is prior consent is needed to use direct marketing communications. Also, the exception to the rule of prior consent, and this is established on Article 13.2 of the e-privacy regulation draft, include email, SMS, MMS, and functionally equivalent applications. Thus, data controllers can use other electronic communication means for direct marketing besides electronic mail with no need for prior consent. This was a discussion, at least it was a discussion for us in Portugal. Now it's completely clear that all electronic messaging, and this is the definition that you will find also in Article 4 of the current draft, the soft opt-in exception to the general rule of prior consent is now applicable to all electronic messaging. As I mentioned before, regarding your question, there is still some doubts on whether push notifications are under this rule, because if you check Article 4.3f, direct marketing communications are defined as any form of advertising, whether written or oral, sent to one or more specific end users. Before, in the previous version, direct marketing communications was defined as any form of advertising, whether written or oral, sent or presented to one or more end users. And so one can discuss now, because there is this expression presented was erased, whether push notifications can be performed by companies without following these rules. Another novelty, and this is important, let's see how the member states will regulate this, but member states can provide by law a set of period of time to use the contact details obtained by clients for direct marketing purposes. And this means that if you are using Article 13, number 2 exception, so if you are using soft opt-in because you have a previous commercial relation with your clients and you want to tell them about your products or your new products or services, now you may be facing, depending on your member state regulation, a maximum period after the moment you get the contact details from your client where you can use them for direct marketing. So I believe this in the previous draft there was an indication for a maximum period of 12 months. Fortunately, it is not there anymore, because there are some type of businesses that will need more time. Additional obligations are in place for data controllers that intend to place direct marketing calls. This has to do with the necessity of having codes or prefix specific for marketing calls. Member states can allow voice-to-voice calls to end users which are natural persons without their previous consent, provided that the right to object is assured. So this means that direct voice-to-voice calls may use the exemption of Article 13.2, provided that the member states allow you to do so. So this is a bit different from the directive. Additional obligations are in place in what concerns the identity of the legal or natural persons on behalf whom the communications are being sent. In what concerns the end user's rights to be informed, to freely withdraw the consent or to exercise the right to object are key obligations. So this means, for instance, that the identity of the sender and a true address, a return address or number has to be put in place. And so very quickly, let's try to see what this means for businesses. You have to comply with the EPrivacy Regulation whenever using any electronic communication means for marketing purposes, including voice-to-voice calls. You will be allowed to use your client's contact details for direct marketing without prior consent, presumably in more situations. We are saying presumably because this dependent on the several transposition laws in the several member states following the EPrivacy Directive. You may have to implement policies to guarantee the contact details are erased after the period of time legally established by your member state. I believe this is key to follow. You will have to identify your calling line and, if applicable, use specific code or prefix that will identify your call as a direct marketing communication. And you may be allowed to perform voice-to-voice calls to end users which are natural persons without their previous consent. For instance, in Portugal, within the EPrivacy Directive, it was arguable if you could perform voice-to-voice calls without prior consent. Our DPA didn't believe so. I believe that we are not seeing drastic changes on the rules for direct marketing, that the EU legislator is missing some opportunities for clarification. I just pointed several, and so let's see how the legislative process carries on and what will be the final solution.
Perfect. Thank you very much, Tiago. We finished our time, so I would like to thank you for being with us today and all our listeners for joining us today. Bye, everyone.
Bye-bye. Thank you.